All right, welcome everyone. Thank you so much for joining us today. My name is Tracy, so I will be facilitating this discussion today. But before we begin, I would actually like to acknowledge the traditional owners on the land on which we meet here today. So I'm coming to you from Darrowland, which is beautiful country out here in Southwest Sydney. And please feel free to also share which country you're based in as well as we go along this presentation. But I would also like to actually acknowledge and pay my respects to elders past, present, and emerging, and any Aboriginal people here with us today. So we should always remember that this land has never been ceded, therefore sovereignty was never ceded. It was always and always will be Aboriginal land. Now, in saying that, we have such an exciting program actually coming ahead. But to begin, I do want to acquaint everyone again to what Zimmer is, and then we'll get to the actual presentation by Darlington Makura, and then we'll have a Q&A session afterwards. And for housekeeping, I would like to remind everyone to keep themselves on mute if possible, just so that we can actually hear the presenter when they're actually talking. Another housekeeping I would also like to make mention of is that the session will be recorded. So if you don't feel comfortable with your camera on, you can always turn it off. But the biggest one, if possible, is just to keep yourselves on mute. The other housekeeping I would like to remind everyone is please feel free to comment throughout the actual session. Just make sure you put all the comments in the chat box, and just make sure you also ask questions in the chat box as well. So I'll be monitoring this quite frequently as we go along. In terms of the Q&A session, I will actually get people to raise their hand using the reaction function. If you know that one on Zoom, just make sure you use that so that I can actually call upon you if you would like to ask your question verbally. So yeah, just make sure you use those functions, and then you can also write your questions in the chat function if you don't want to ask. Now, without further ado, I'll just give you a bit of a Zoom overview on what Zimmer is. So the Zimbabwean Association in Australia Incorporated was established in 2018 by a group of dedicated volunteers who are here to actually cater for all the Zimbabwean people in New South Wales. And as a member, I'm actually really proud to say that our vision is really to promote and to preserve and resource our community and try to remain instilled in our cultural values and traditions within that multicultural Australian community. So Zimmer really strives to preserve a lot of that engagement with the Zimbabwean culture by facilitating social, cultural, and educational events within the wider Australian community. And we do, as a Zimmer collective, we do intend to enhance social cohesive opportunities between Zimbabwean and Australian community. In terms of initiatives, I'm sure you've seen a few initiatives that Zimmer actually does, not just a few, it's actually quite a lot. But we have done quite a lot of things which range from assisting community members with bereavement support, fundraising activities, and Zimbabwean soccer tournaments. Sometimes we support that as well. And the biggest one that everyone was in attendance last year was the annual gala, which was fantastic. And I'm sure, as you know, we'll have another one this year as well. So I'll be looking forward to everyone hearing that announcement soon as well, once everything is finalized. But of course, this is not about just what Zimmer does. This is actually about really sort of understanding wills and estate planning today. So without further ado, I'd actually like to introduce our guest speaker tonight. So we have Darlington Makura, who studied at the University of Zimbabwe, and he was admitted as a legal practitioner in Zimbabwe in 2000. He has worked for one of the oldest law firms in Zimbabwe, which was Galen and Holderness Legal Practitioners. And he's also worked in-house legal team for British American Tobacco. He has also worked in the corporate advisory team at Imara Capital and worked in a team that provided advisory services in financial transactions to corporates in Southern Africa. In 2007, he migrated to Australia and commenced further studies at the University of Sydney and the College of Law, and he was then admitted as a solicitor in 2008. He then worked in general law practice in Parramatta Regency Lawyers, which involved commercial law and litigation as a senior associate, and then left to work for Galilee Solicitors, which was a mid-sized national Australian law firm, providing legal services to regional banks, lenders, and in areas of lending and mortgages. In 2013, Darlington started Exodus Lawyers, which advises clients in the area of property law, conveyancing, estate planning, and commercial law. Exodus Lawyers is strong on collaborating with other related professionals in providing integrated advice to clients. It is quite evident that our guest tonight has a wealth of knowledge and has a lot of information that he would like to share with us today. So we're quite honored to have you, Darlington. So if you would like, please start presenting, Mr. Darlington. Welcome.
Thank you, Tracy. As indicated by Tracy, I originally trained in Zimbabwe and came to Australia, and I'm now with Exodus Lawyers. I'll just give you a brief background to wills. I think it's always a good idea to have a will. It's always a good idea to think about, what happens when you go. It's part of that whole process of there's always a talk of building generational wealth and all of that. So the beginning is by to get that process started is to think about how you essentially have those assets distributed after death, which happens to all of us. So the first question is, what is a will? So a will is a document which expresses a competent person's wishes about the distribution of their testamentary assets after they die. So the will also deals with the nomination of an executor, the appointment of a trustee, and the appointment of a testamentary guardian, and also deals with, in some cases, how people wish their remains as to how they're disposed. But anyway, just to explain it further, I guess the first question is, what happens when you die? What happens when a person dies? So the first thing is all the property becomes part of what is known as an estate. And if there's a will, the person who's the executor makes an application to the court. If it's in New South Wales, it will be in the Supreme Court for a grant of probate, which allows them to distribute, the assets. So yeah. So the person who applies for that probate is the executor, and then the person, once they get the order of probate, they then distribute those assets according to the wishes as expressed in the will. So the process of probate is just the court validating the will. So the role of an executor is very important because they are the ones that manage the assets before that distribution is made. So what makes a valid will? To be a valid will, there are certain formal requirements that must be present. So it relates to the way the will is signed and also witnessed. So a poorly prepared will can result in additional costs to the estate. Also take care, there's more use of technology these days, and people may want to use technology to prepare their own will documents. If you do that, just take care of the way the will is signed and also the witnessing. So the will must be signed by the testator, that's the person making the will. Then it must be signed before 2 adult witnesses. And the witnesses must attest and sign in the presence of the testator. And people who are benefiting from the will should not be witnesses. Why should you make a will? So if you don't have a will, the laws of intestacy will decide how your property is divided. So you're essentially leaving that to a judge of the court to make that decision for you. And if that happens, some of the people you would like to provide for may not receive anything. They may also end up applying to the court for provisions from your estate, again, which is a process that costs money. And the court will appoint an administrator, and you will not have a say on who that person is. And they end up managing, your assets after your death. Then another important issue is you will also not have a say in who becomes the guardian for your minor children. So you leave that to the court to make that decision for you. But generally, there's more efficiency in the administration of the estate if there's a will. So so I gave the example of what happens if you die. If you have a will, the executor goes to the court. If there's no will, you still have to go to the court and letters of administration issued. And then the court decides who is going to be in charge of the process and who gets what, So there are guidelines from the law as to how that decision is made. But obviously, it's better that you plan and you plan all those things and have a will done. And obviously, it's cheaper as well. Because if there's a will and the executor is going to the will, it's just a process of validating the will, just confirming it was signed properly, it was done properly, and then they'll make an order of probate. Then the next question, do I need a solicitor to make a will? Obviously, it is possible to make your own will, but it is not recommended. Homemade wills, there are lots of cases regarding how showing the problems that arise when people use homemade wills, which end up causing delays, uncertainty, and increased legal costs. So usually the cost of consulting a solicitor to make your will is way less than the cost of potential problems that may arise if there's no will or if there's a poorly made will. Your will may also be challenged, but again, if you consult a solicitor, you have someone sounding out your ideas and questioning some potential issues that may arise. For example, there may be people that are not covered in the will, and you may need to address the reasons why they're not covered. Maybe adequate provisions have been made in other ways, that sort of thing, which would limit the potential litigation arising after your death. Then obviously, with wills not being signed or witnessed correctly, I guess if you have a solicitor, they'll make sure that that process is done properly. Then there may also be some terms that are used which are confusing, which may need to be clarified. So those are the advantages of having a solicitor prepare your will. And you may also choose to have other professionals help you in your planning, depending on how complex your affairs are. So some of the problems that are encountered with the signing and witnessing of the wills, there are various cases, even some famous people who make these mistakes, and some of them have been in the media. So, for example, a will kit may be formed. A will kit form is filled out, but it's not witnessed or signed, or alterations are made, but they've not been signed and witnessed. The will may refer to a list, but the list has changed since the will was made, and the list is not signed, or the alterations are not signed or witnessed. And one of the witnesses used may be an intended beneficiary under the will, which would invalidate the will. Also, it's important to make sure that the language used is clear and it's not ambiguous. The will should be capable of being understood by someone who does not necessarily know anything about the will maker's circumstances. So obviously, if the wording in a will could be construed to mean more than one meaning, then an application will need to be made to the court, which would then decide what the meaning that should be attributed to the will, or we should decide how the will should be interpreted. Again, you don't want that because that's costly. So some of the problems that have been seen, people say, giving a gift to my family. Who is my family? How is it intended to be shared? What's the formula? What's the ratio? All that, all those kind of questions. I'm giving a gift to my nieces and nephews. Does this include your nieces and nephews from your wife's side? Does this include children of your half brothers, half sisters? All those things will need to be clarified. So these are some of the problems that tend to be seen when people try to do their own wills. So when we prepare wills, there are also other documents that we encourage and that we prepare as part of the will package. The first one is called an enduring power of attorney. So unlike a will, so we said a will decides how property is going to be distributed after a person dies. The enduring power of attorney deals with a situation where someone is still alive, but they lose mental capacity or they lose the capacity to make their own decisions. And then it's deciding what the power of attorney does. The principal gives the attorney the right to do anything that the principal themselves may lawfully do. So examples of so the power of attorney applies to financial issues and may be used in the buying and selling of real estate, operating bank accounts, managing self-managed superannuation funds. And of course, there may be limitations as to how these powers are used that are made in those documents. For example, some people will say, I only want my power of attorney to apply when a doctor issues a certificate to say that I'm no longer able to manage my own affairs. So there are protection mechanisms that can be used to deal with any potential risks. So as I said, the power of attorney, the enduring power of attorney, which is done when someone is working on their wills, is different from the normal power of attorney in that the power carries on even after the principal loses mental capacity. Then the other document is called an enduring guardianship. So what an enduring guardianship does is it enables the appointee. So just like a power of attorney, it applies when someone is still alive, but they've lost the ability to make certain decisions. So what the enduring guardianship does is it enables the appointee to make lifestyle decisions. For example, what healthcare a person may receive, what medical decisions the appointer may, what medical decisions may be made on behalf of the appointer. Obviously, the guardian appointee must be guided by the welfare and interests of the appointer. And it's important to consider family relationships, cultural and linguistic environment issues, and ensure that the appointer is protected from abuse and neglect. So yeah, so just to summarize those two documents, the power of attorney, it deals with financial issues. So you're still alive, but you've lost the ability to make decisions. Then the person who is your attorney is able to operate your bank account, is able to make financial decisions on your behalf. Then with an enduring guardianship, you've lost your mental capacity, and that person decides the healthcare you receive or the medical decisions. They make medical decisions on your behalf. They decide where you live, that sort of thing. The next topic I'll deal with is a testamentary trust. Some people want to know about testamentary trusts. So a testamentary trust is a situation where in the will, so remember we said in the will, the testator appoints beneficiaries who get a portion of the property after probate is granted. In a situation of a testamentary trust, everything goes into a trust, and the trustee, the property exists in a trust, carries on existing in a trust, and the trustees will distribute to the beneficiaries, some payments or living costs or cost of education, but the property is always in a trust. So that's called a testamentary trust because it's coming out of a will. So some scenarios where this may be necessary. I've tried to think up of a few situations where this might be necessary. So for example, you're still young, you're a young person, you're worried that if you die, your partner may get married to someone else and they'll have more children, and you're worried about whether that inheritance will still exist for your children or it will now cover other children. Other situations for younger people will be a partner dying, and there's a new spouse, and you're worried that maybe that relationship may not may go through a divorce or family proceedings, and you want to ensure that the property is always separate from the other property. So hence you always keep it in the testamentary trust. Then also coupled with adult children, older people, I guess they'll be worried about their children going into romantic relationships, and then maybe those relationships do not work, and the inheritance may be exposed to family law proceedings, divorces and all that. So even though family law deals with inheritances, I think over time, that wealth may, or rather that inheritance may be mixed up with everything else. So yeah, so in that respect, a testamentary trust would always ensure that the inheritance is kept separately from the other assets. Then also, children may not be financially mature. So instead of giving them everything when they turn 18 or 21, you want to keep it separate, and then they only get certain payments every year, but the inheritance is always intact. Obviously, that trust relationship can exist for up to 8 years. Then another reason why people have testamentary trusts is some children may be living overseas where there's high taxes on inheritance, and you want to protect that inheritance from taxation. So if all the property goes in one go, it's then taxed in those jurisdictions. So you'd rather keep it in the trust, and then they're only getting small payments every year or whatever period is deemed to be necessary. Some of the problems, some of the issues to think about when you're thinking about the wills that you get to address. You think about who have you nominated as the guardian for your children, if you have minor children. So we spoke about the testamentary trust. whether it's necessary. Then also, the other things you can think about as well are backups to key roles. So for example, executor, if they are not able to act, who is the backup? If they don't want to act, who is the backup? That's the same for guardians of minor children. There are also issues of practicality and all those things. So yeah, it's worth thinking about backup to key roles. Then superannuation assets, they tend to be dealt with separately. They don't go into the estate. So you need to have what is known as a binding death benefit nomination. But in that binding death benefit nomination, you can also advise, you can also instruct for the super benefits to go into your estate. So another problem is, I think appointing an executor who's not willing to act, but that's the same point with having someone as a backup, having backup to key roles. Then you can also communicate to your children's guardian what your intent and wishes are. So it's common now for people to do, in addition, after they appoint a testamentary guardian, to have a letter of wishes, just saying, oh, these are how I wish for things to be done. Then also another topic is there are professional executors. There are situations where it may be necessary to have professional executors. So they are there. I think one of them is the state trustees. So for example, where you have no one that you trust, they also, I think other banks also offer that service where they can be professional executors or professional trustees. So say you don't have family or friends that you trust, but obviously they charge for that process. So as indicated, there are problems in making your own will. And obviously those problems will only be discovered when it's too late. Unfortunately, it comes on much later. And those problems will be costly to resolve. So having a will is just a simple way of a simpler way of mitigating those problems and dealing with uncertainties as to how your estate will be distributed. That's I'm okay to take questions.
Thank you so much, Darlington. That was such an informative presentation. I've got so many questions, but I would rather open it up to the floor at the moment. So if everyone who's interested raising their hand, that would be great. And I can see there's one person already. Levi, I'll come to you in a second because I've seen one from Bessie. She wanted to know, well, her comment is, also want to know about estate duty. I heard there is an insurance you can get for that. Is that true?
Estate duty. I think a financial planner is probably best placed to deal with that question. But yeah, I think there is insurance for estate duty. Or at least there will be some kind of product that deals with how to deal with that.
Thanks for that, Darlington. I'll come to Levi now. If you would like to unmute yourself and ask your question. Thanks.
Okay. This is probably one of the stupidest questions I can ask. You know how when we nominate people to be those that are going to preside on the estate, say when you're gone, how would you know, or maybe, I don't know how to ask this question, you don't know who's going to die first, either myself or the person that I've nominated. Do you nominate a second person just in case the first one dies, or how does that really work in practice?
Yeah. So yeah, I think one of the points I made was to always think of backup. Backup. So the way it will be worded will be, I appoint so and so to be my executor. So you can appoint. So firstly, you can appoint more than one executor. Then you empower. You can say I appoint John and James to act jointly. So you could say I only want them to act jointly. But then you can also say I also want them to act jointly and severally, meaning they could work. Well, either one of them could work on their own. So you could have that. Then you could also have a substitute. You could say I nominate John first, but if John does not want to act or is unable to act, then I appoint James. So yeah, those are all issues that will be discussed. And so you also look at the age of the person that you have appointed as executor. Will they, what are the chances that they'll still be alive? Then you can have a substitute. Then you can also have, as I said, you can also have two people being appointed jointly.
Okay, thank you so much.
Awesome. Got a few in the chat at the moment, so I'll just ask one in the chat and then I'll come to the people that are raising their hands. So Petronella asks, how binding are the wishes listed in the letter of wishes?
So they're not binding, but I guess they're more if say you appoint someone to act as your testamentary guardian, and then you have that letter of wishes, it may not be binding from a legal perspective, but at least it gives them an idea of, like, an idea of what you. So I would imagine you'd have thought about the person who you have appointed, but it gives them a direction. It gives them something to work with. It clarifies their role. So even though it may not be binding, but it helps. It helps in them understanding how you would have wanted things to be done.
Awesome. Thanks for that. I'll go to Rurimba next. She had her hand up before.
Hi guys. So I just have a quick question. So let's say you're in the process of getting married and you have created a trust beforehand. Now, when you get married, and if you go through a divorce or something happens where you pass away, what happens to that original trust that I've created under my name and that was insured and everything was created for it in terms of going to my kids, like it had things that I established? What happens then when I then get married and then when I then divorce and when I then pass away? Will it go towards my husband or will it still remain intact?
Okay. Yeah, good question. Sorry, I think there are a couple of questions in the same sentence. So you're saying you're married?
So I'm saying, let's say right now I'm not married. I've created a trust and it has a will and everything in it. Now I get married. What happens to that will and trust before? Because I know when you get married and you divorce, and what happens to the separations of everything? I know it's a bit of a complicated one.
Okay. So the question firstly is, you own property, you get married, the property is owned in your personal name.
Yes.
And then you get married. What happens when you divorce?
Yes.
So that's more family law. Generally what happens, everything goes into some kind of a pool. and then they'll take into consideration, your contributions to the marriage. And they'll also consider other factors, for example, your earning capacity, what the other person brought in, what you did during that marriage, and then the judge at the family court of a federal court will come up with some kind of a percentage, and that will be used to distribute the assets after a divorce, or after the breakup of the marriage, or a relationship, a de facto relationship. The other way, you were saying, if the property is in a trust before.
Yes, so it's in the trust before, and then I pass away, and so let's say that trust has never been amended or changed, and it was established before me getting married, and it had beneficiaries. It was going to go to people, and my partner has never touched it nor put any money into it. Will it still remain intact, or like never contributed or had anything to do with it?
Yeah, I think it will remain intact. So you're saying the property is separate from, it's not owned by you, it's owned by a trust.
Yes.
And then you get married, and it's
Yes.
clear that property, obviously, as long as you're not using the money from, you're not growing it from the money after your marriage, so that your partner will not claim that you're using money from the marriage to build those assets. But if it's separate, property, where you owned, you set up a trust, and everything is in a trust, and you get married, and there's no additional funds put in that trust, then yeah, it's separate property.
Okay. Thank you.
But I mean, there are safer ways as well to deal with that, to make it clearer. You could also have a binding financial agreement. I think it's what many people call a prenup or whatever, but it's called a binding financial agreement in Australia, where you clarify that you're getting into the relationship, but you've got your own assets, and they're not going to be part of the assets that you own together. But if it's separately owned, and you ensure that it's clear that it's separately owned, you're not using any money to build it, then I think it should be separate.
Okay. Thank you for that.
Yeah, I think that's an interesting topic, and Darlington, maybe you might have to do another presentation. So I've got a question for Morgan. He had his hand before, so I'll just call him up now.
Hey, Darlington, this is really good. Really appreciate it, and I think you're doing a great thing for the community. I like that you've also worked in Zim, so it's experiences across Australia and Zim. Now, my question is, I'm thinking that on this call, there'll be people that as well own assets in Zimbabwe. That's the first part. And then the second part is that there are people that may have beneficiaries in Zimbabwe. So it's not just Australia we're dealing with here. So is there any difference or any consideration or something we need to think about in relation to a situation where someone owns assets in Zimbabwe? So when they're drawing up their will, is there any special consideration they need to bring to the fore? And then secondly, in providing wills, and you have family, let's say dependents or mom and dad, that you are regularly sending money back to Zimbabwe, and you want them to be taken care of, is there any consideration when you're putting together a will in relation to that scenario? Thanks.
Yes. Thank you, Morgan. So yeah, so the first part of the question was, how do you deal with assets in Zimbabwe? I think
Correct.
Yeah. So generally speaking, the will in Australia should be recognizable in Zimbabwe, but it's also possible to have two wills, as long as it's clear, I guess, in the wedding that, because one of the wedding they use, or commonly used when people are drafting wills is to say, this will that I'm doing is invalidating all the wills that I've done before. So if you consider it necessary to have a separate will for the Zimbabwe assets, then it must be clear in the Australian will that there are two wills, and the intention of the other will is to deal with the Zimbabwe assets. Then the second part of the question was, how do you provide for beneficiaries in Zimbabwe? So I guess it's just the same as the beneficiaries in Australia. So you can say I am giving, say, but again, I suppose the person that you think of as executor must also be able to apply, to make sure that the wishes are provided for. But I don't think it will be a problem. For example, if you say I wish for $60,000 to be given to my mother or my father or my brother, the executor will, I guess, will make contact with those people and just ensure that they're provided for.
Thanks, Darlington.
But I think also, generally speaking, I think the will in Australia, even if there was no will in Zimbabwe, should be generally should be accepted by the courts there. But it's also worth, I guess, if you have one, sending it over to someone in Zimbabwe to have a look and ensure that there are no problems.
Right.
Thank you.
Thanks so much for that. I'll go into the chat. I believe there was someone there, F. Makumbe, who had asked, I know it varies by individual, but what's the typical cost to get a will done by a solicitor?
So just there's the normal wills where they're not testamentary trusts or anything. I think it'll be maybe for a couple $600, $700, $500, $700. For an individual, maybe $300, $400 thereabouts. Then where they're testamentary trusts and more complex, it can be a couple of thousands thereabouts.
Awesome.
But yeah, it's generally as indicated, as I indicated, I think many people are not aware of the process of what happens when a person dies, because I think historically we haven't been dealing with these things in the same way. So you still have to go to court without a will, and that will cost you more if you don't have a will. So that money is really it's not, so having a will is actually saves you more than not having one.
Yeah, it definitely seems like it for sure. I'll call upon Archineka, who had their hand up as well, so I'll just get them to ask a question.
Thanks, Tracy. Thanks, Darlington. Very scary, very insightful at the same time. My question is, when you have the testamentary trust, you trust someone and you appoint them to take care of business when you're gone. But then what happens if that person abuses the beneficiaries and appropriate whatever was left for their own personal gain?
It's an important question. Obviously, if they're doing their job properly, they need to account for every cent. But obviously, there may be instances where I would imagine there may be instances where you can't trust anyone to be able to do it properly.
Yeah.
And in those instances, it may be worth having those professional executors. They do charge, since some of the charges, some of them charge up to 4% thereabouts. But you've got that security that the job will be done properly.
Sure, thank you.
So I think many banks have that service. Many the state trustees they also do that.
So thank you.
But it's also worth thinking through as well. So I think other things that you can do is to have. Remember, I said you can appoint joint. So you can say I only want so and so to act as the executor, but at the same time he must act with so and so.
Yeah, I think the biggest challenge is between married couples. Okay, fine, you trust your partner, and you would assume when you're gone they're gonna look after the children, but you're gone and maybe they remarry and they are channeling the benefits to their new family.
Yes. So maybe in that instance, just trying to think. So without a professional executor, it could be maybe if you're a lady, or maybe you could have your brother or sister act as a joint executor as well.
Yeah, makes a lot of sense.
Yeah, and hopefully it will then provide a check, some kind of a check in the system, or a testamentary trust with a professional executor as well. But it may be difficult to convince a spouse but yeah, those are all potential solutions. So either a corporate trustee, or maybe having someone else as a joint trustee, joint executor, joint trustee.
So a follow-up question would be, is it by any chance possible for maybe the other family members to challenge the executor, or under those circumstances?
I guess it will be. It is possible. It is possible. I guess they just need to establish that the beneficiaries, I guess they need that assistance, because I guess they are minors at that stage.
Yeah. All right, thank you. That's about it from me. Yeah, very, very informative. I really appreciate. Thank you.
Thanks so much for that. I'll just go into the chat now because I've seen another question. So there's Lawrence who asked, are there any requirements to become an executor, legal or in any way?
Just above 18 years old.
Awesome. And I will go back to someone who's raised their hand, Sekai and Ludzai. So I'll just get them to ask their question.
All right, thank you very much. Just thank you again, Mr. Makura, to start this conversation. I know in our Zim culture, it's not an easy topic, but thanks for starting this discussion. My question is about, you mentioned earlier on that if a person dies, obviously their resources are put into a trust. I was hoping you would maybe provide a comment about joint assets. When like married people, they are operating their assets jointly. Could you just shed some light about that? Is everything going to be put in a trust account? To an extent, you have issues accessing money to bury the deceased and things like that. Do you want to comment on that?
So with property, there's so you in Australia you can own property in two ways. There's you can own property as tenants in common or as joint tenants. So if you own property as joint tenants, it doesn't go into the estate. It goes to the surviving party. So common assets are like, say for example, the matrimonial home. Most people usually own it as joint tenants. So meaning when one person dies, it goes to the other automatically. But if you own property as tenants in common, meaning meaning, for example, I own a property and I own a separate share of that property, a separate 45% or separate 50% share, then yeah, that property goes into the estate. Yeah, I don't know if that answers your question. So it depends how you own the property. So if you own the property as joint tenants, then it doesn't go into the estate.
Okay.
It goes to the surviving joint tenant. So usually your family home is owned in that way. But it's more the property that you own as a tenant in common or separately. That's what goes into the estate.
All right. No, thank you. Thank you very much.
That's okay.
Thanks so much. I'll just go back into the chat. More Blessing had asked, how long does it, so it's a two-part question. How long does it take for a will to be prepared? And can I ask my wife or husband if they're in hospital on deathbed or they have been diagnosed with cancer to quickly write a will?
As long as they're, so remember we spoke in the definition of the will about a competent person. So the competence is really, do they have capacity to make, you know, to be able to make decisions? Do they know what they're doing when they're making the decision? So even though they've got cancer, do they know or what they're doing? Are they capable of giving instructions? I guess the lawyer taking the instructions will need to decide that. So actually one of the declarations you make on the power of attorney when you're signing a power of attorney is that as the lawyer that you believe that the person understands what they're doing, knows what they're doing. So if the lawyer is satisfied that that person knows what they're doing, then yes, it can be done. And how long does it take? It just depends. It just depends with the lawyer doing it. It might not take long, maybe just be a couple of days or, but usually it's worth having a meeting where you give instructions to the lawyer. I usually find that more things come out after that discussion. Then the drafting of the will itself does not take a long time.
Yeah.
But like certain twists come in when you talk to people. There are things that they wouldn't have thought about. There are things that are hard to think about. Like say, for example, what happens if both of you die at the same time?
Yeah.
Yeah, that question is a bit hard for many people to think about, but it needs to be taken care of, I guess. Someone needs to think about what happens in those circumstances.
Yeah, no, there are definitely lots of questions coming in, but in the interest of time, I'll sort of select the last 4 people that have asked questions, and then we'll cap it there so that you're not having to be over time. So I do have a question, I think I did see Ronald putting his hand up, so I'll just ask him to come and ask his question.
Yeah. Thank you. Hi, Darlington. Hi, everyone. I'm actually a client of Darlington, so good to see you and thanks for the presentation. Just had a quick question. In terms of our relatives who are back in Zim, so like our parents who might have worked and have assets, but do not have wills, is there any advice or are you able to help us, or do you have partners in Zim that can help them, or can they do wills from here if they're here, but their assets are in Zim? That's pretty much my question. Thanks.
Yeah, thanks, Ronald. Ideally, probably best for them to have someone in Zim do the will. I'm okay to give you some referrals and talk to some of my friends in Zim, see if I can refer you to them.
Awesome. I've got a question from Deliwe. She has two questions. So this binding financial thing, how much is it understood by our people? Can we have more information about it? And then the second question is, does it bring a challenge of uncertainty when getting married, considering our cultural background?
Or the binding financial agreement. So yeah, so the question is, would it bring problems given our cultural? I guess it might, but it's only one of the ways, I guess. I think one of the examples she gave was putting everything in a trust and then trying to separate or make it clear that, when you're going into that marriage, that this is not coming, this is not going to be part of, I guess it then depends on how she structures, how that arrangement is structured to make sure that it's bulletproof. To say that this is not something, these are not my assets. I would imagine the beneficiaries, the beneficiaries and the trustee, you need to think about, I guess, how to do it in such a way that it's clear that it was never intended to be assets coming into the marriage, and also maybe make it clear to your partner as well that it's not coming into the marriage. But the other, the binding financial agreement, I think there are ways to I guess, to communicate why you're doing it. I guess if you think about valid reasons, so maybe the partner would understand. I've seen a client who was able to articulate to their partner why they were having a binding financial agreement. So it's just explaining, I guess, finding good reasons and explaining to the partner. But also there are other ways, I guess, as I indicated, that the way the trust is set up, or a company, and make it clear that these assets are not my personal assets. They're not coming into the marriage. I've set them up for A, B, C, D, E reason.
Yeah, no, definitely quite an interesting conversation there as well.
Yeah.
The last, we'll have to make this the last question just because of time, but we had a question from Esnath. She asked, does a will include where I want to be buried, and can that be challenged?
Yes, it does. It's optional, I guess, but yes, you can indicate that. I think in my definition, I said how your remains are disposed. You can have a clause stating that some people will say, I want to be cremated. Some people will say, I want to be buried at a specific place. Obviously, there may be some limitations, for example, financial resources. If there's no money in the estate, the executor may not. So you may say, I want to be buried in Zimbabwe, but then there's no money in the estate, so the executor will not be able to make sure that those wishes are satisfied. But yes, that you can include those directions in the will.
Mm-hmm. No, thank you so much. I can definitely tell that there was appetite for this conversation. As you know, there's so many questions. We didn't get to everyone else, but thank you so much, everyone, for being patient, and thank you to Darlington for actually being able to answer all the questions. It really went over the time that we agreed on upon question time. But where can people find you? Because I'm sure there's still going to be questions. Do you have a particular contact address or anything like that you would like us to share with people?
Yes, I'm based in Parramatta, level 7, 91 Phillip Street in Parramatta. I can give you an email address and a phone number.
Yes, certainly. That would be great. And we'll be able to share that. But we thank you so much for taking the time to actually come here and share your wisdom with us. So thank you so much. And on that note, we'll actually end this session. Thank you everyone for attending, and please make sure you complete the evaluation form. It just kind of helps us actually understand what topics you're interested in, and I guess how to structure the next sessions for you as well. So thank you so much, and we'll end it here, and I'll stop recording.
Thank you.
Thank you. Bye.
Thank you so much.
Thank you, Tracy.